So in this video, we'll deal with res subjudice and res judicata. So section 10 deals with res subjudice. So these are some essentials of res subjudice. There are two suits, that is previously instituted and subsequently instituted. So matter and issue in both suits are same. Matter and issue in previous suit as well as in subsequent suit are both same, right? So that is first is essential. And the parties in previously instituted suit as well as subsequently instituted suits, the parties are same, and they act upon the same representative character. And the previously instituted suit, that is previously instituted suit, is pending before any court of India, and such previously instituted court, uh, previously where the suit was instituted, that court has competency to grant any claim. In a simple sense, it had jurisdiction to try the case and grant a claim. And uh, in both previously instituted as well as subsequently instituted, in both the case, there are same parties under acting under same title, and the trial of such suit will be barred. So it is important to note only the trial of such suit will be barred, and it will not be that it will be dismissed as soon as the suit is filed. No, it is not the case. It will be heard, but it will be stayed. It will not be uh, continued. It will be stayed there. So trial is generally barred, and yeah, suit is not been dismissed but stayed. And that is one of the point that we can make with which we can make a distinction from res judicata and res subjudice. So suit can be stayed at any stage. It is mandatory. Checking for res subjudice is mandatory, but it can be waived by the parties. The other party may not contest res subjudice, or it can even waive off its rights, and the court may still proceed to not to stay the suit, and it can proceed with a trial even in that case. So generally, we should know that it is mandatory, but it can be waived by the parties. So when degree is passed in contravention of section 10, that is res sub judice, if any decree has been passed in contravention to this particular section, then it is not a degree of nullity. It can still be a valid decree. And that is about res sub judice. And now we come to res judicata. Res means a thing, judicata means which has already been adjudged or decided. So it is a fundamental doctrine that is based on conclusiveness. So a litigation should always have conclusiveness, conclusiveness in the interest of the country, nation, and the public as well. And there should always be a finality for particular litigation. And the relevant case law that I would urge you guys to refer is Chandrasekharan versus Siddhivinayagar Temple. And that is a very important case law when it comes to res judicata. So res judicata operates as a bar, right? It is not about staying a particular suit or where trial is not being proceeded, it is just been stayed. It is not the case. Here, the suit itself is barred at the first instance. The party cannot even file a suit. In res sub judice, it is different, where it is allowed by the court. The filing procedures are done, and only then the court will uh, put stay on a particular case. But in res judicata, the court will dismiss the suit at the first instance itself, and it is a legal concept that is, yeah, that is based on, these are two legal maxims that I have translated in English. In the interest of the state, there should be an end to a litigation, and no one can be vexed for twice for the same cause. So this also applies for double jeopardy when it comes to criminal law. But in civil law, it shall also be applied with the concept of res judicata. No one shall be vexed twice for the same cause. And yeah, in that Dario versus State of UP, it was held that the concept of res judicata is based on public policy, and the concept res judicata applies for all judicial proceedings, quasi-judicial proceedings, that is, the proceedings before tribunals and appeal, and in miscellaneous proceedings and arbitration as well. Mm. It is mandatory, but it can be waived off by the parties, uh, similar to res subjudice. The criticism is that this concept does not promote absolute justice. So there are some criticism to this res judicata, as this is being very strict. Like it may not promote absolute justice. There are criticisms with such nature. That is when a outcome of a former suit, where that former suit, the outcome has been decided in merits. In such case, if such outcome is erroneous, that cannot be changed later, because when a particular case has been decided before, even though such decision is erroneous, even in that case, a further suit of similar nature or similar kind cannot be filed, even for sake of justice, right? So sometimes res judicata, there are criticism that res judicata may not provide or promote absolute justice. So essentials of res judicata is there are two suits, former suit and subsequent suit. So former suit is a suit that was first decided and is not first instituted, right? So this is very important when it comes to res judicata. So former suit is a suit where which the court has first decided and not instituted. That is really important, and that is provided under explanation 1. So there are 8 explanations that are given under section 11, and the section itself is very big. So matters must be directly and substantially in issue in both the suits, like both in former as well as in subsequent suit. The matters in issue must be directly and substantially in issue in both the suits, whether it could be with related to law, issue of fact, or mixed. So generally, matter must be directly or substantially in issue in both the suits, and that particular issue must have been alleged by one and denied or admitted by another. And the prior suit between the parties must be of between the same parties claiming under them, like their representatives. If the parties must be same in both former as well as subsequent suit, and the parties must be contesting in same title and same capacity in the former suit as well. And we'll deal with explanations now. Explanation 2 deals with competency of a court cannot be determined based on its superior court's appellate jurisdiction, right, over such case before it. And explanation 8 deals with uh, res judicata will apply to decisions given by court of limited jurisdiction as well. For example, if there is a uh, rent case, like rent issue case, then it goes to rent control courts, right? Then a decision that has been given by rent control court cannot be again be challenged in civil courts as a different suit under different grounds, because that case has already been adjudged by rent control courts, and same matters cannot be filed before other civil courts in a different court under different remedy, under different grounds. And this is one of the important statements when it comes to res judicata. Such matter in issue that has been decided in former suit must be heard and finally decided on merits. It should not be like dismissed on limine. Limine in the sense those those suits which have been dismissed on procedural grounds. For example, stamp duty has not been paid, and there will be other procedural uh, grounds where the court would have dismissed a particular case. So that will be termed as dismissal on limine. So dismissal on limine will not attract res judicata. That is the thing that we should know. And res judicata applies to ex parte. Ex parte in the sense, uh, even there are some cases where ex parte proceedings will take place where the defendant will not be present, even though, even in such case, the court would have not given in favor of plaintiff. So in such case, res judicata will apply to ex parte, and res judicata applies in execution proceedings as well. So as per section explanation 5, if any claims that have been put forth before the court, but the court had not granted that particular claim which have been sought, in such case it can be construed as a refusal to grant, right? So it can be deemed as court has not as rejected such claims. And explanation 4 deals with constructive res judicata. This is very important. So all claims must be made at the first time itself. Like, if a person have a particular claim and he has right to claim, then he should make all claims in a particular suit itself, in the first suit itself. He cannot claim a particular he cannot put forth his claims like one by one. He cannot do like that. If he has a bundle of claims, he have to seek for every claim that first time itself, that first suit itself, and you cannot further ask for different claims on different grounds. So grounds might or ought to have been taken, should have been taken in the former suit itself. The relevant case would be Srinivasan versus Secretary to the government of Tamil Nadu. And there are two last explanations, that is explanation 6. So res judicata will apply to representative suits, and explanation 7, res judicata will apply to execution proceedings as well. And that is about res subjudice and res judicata.